If people want to just find their seats, we'll get started just in just a moment. I guess we'll go ahead and call the meeting to order. My name is Andrew Rennick. I am chairing this evening's meeting of the Board of Adjustment here in the city of Provo, March 20th, 2023, meeting at it's like 5:02. Just by way of announcement, if anyone here who is here for item 3, the Daniel Brough, I'm not sure I said the last name, variance request, that has been continued today. Let's see. Let's go ahead and have each the members of the board state their name and whether or not they have any conflicts of interest to declare on any of the items this evening.
I'm Eric Chase and no conflicts.
I'm Laurie Urquiaga. I am recused from the first item because I heard it from the Planning Commission.
Again, Andrew Rennick and no conflict of interest.
Maria Winden, no conflicts.
Right. Well then, with that, we will jump in. Our first item, I will read into the record. David D. Jeffs requests an appeal of an administrative decision by the Planning Commission for denial of a revocation of a conditional use permit for a monopole tower located at 1499 North, 2200 West in the agricultural A1 zone, Grandview South and North neighborhoods. So we'll start with our staff report as Mr. Larson is away today. I believe that Bill is taking over.
Thank you. This is a request to overturn a decision by the Planning Commission regarding a cell tower located in Grandview. In June of 2022, the Planning Commission approved a conditional use permit for the subject cell tower. Because conditional use permits are not a regular part of Board of Adjustment hearings, let me provide some background. In Utah, there is a supposition for approval of conditional use permits unless it is demonstrated that the use is causing an impact that cannot reasonably be mitigated. Cities are not permitted to use supposed health impacts from radio waves or electromagnetic waves as the reason for denial of a cell tower. And in Utah, there is no property right to a view corridor. Part of the conditional use approval necessitated moving the tower's location from where it was originally proposed to meet the 160-foot setback from a residential zone boundary line as required by ordinance. The required setback of twice the height of the cell tower is intended to mitigate the impact of the height of the structure. The setback is the ordinance mitigation measure for the height of the cell tower. On January 25th, 2023, the Planning Commission was asked to revoke the conditional use permit. To revoke a conditional use permit, there are specific criteria that are used. Please keep in mind that the January 25th Planning Commission hearing was not about rehearing the original conditional use application or whether an error was made in originally granting the CUP. In other words, it was not an appeal of the conditional use permit. The January 25th hearing was about whether or not the criteria for revocation of a permit could be met. As you have read the staff report, the Planning Commission found that the request did not meet the burden of proof that there was insufficient grounds to revoke the conditional use permit. Let me show you some slides just to give you some context to where we are. So here we are in Grandview. The subject property is outlined in red. Mr. Jeffs, it's working. Okay, you can see the subject property. You can see the zoning. The A15 zone where the cell tower is located versus the R110 zone. In between the two properties, that's kind of a frontage road, access road that's used a little bit. The public road is out here. Some of the photographs you'll see in this presentation were taken from that access road. So you can see the site of the original proposal. So that original proposal was down between the two buildings down in this area. And you can see because of the narrow width of the property, that wasn't 160 feet from the zone boundary line. The proposal, the current location here does meet that setback requirement there. So that's the original proposal. Whoops, I'm sorry. This is a little skittish. That's where it was moved to in order to meet the code requirement, the code setback. So that's from the access road looking to the east. You can see a substantial change in grade or contour. Another picture from looking to the east. Now looking to the west. So that snow-covered building there is the red roof that you see in the photographs. These are the criteria that the Planning Commission used for the revocation of the permit. Has the fall administrative appeals, the Board of Appeals to the Board of Adjustment. The burden of proof is on the applicant, and the applicant must show how the Planning Commission erred in interpretation or application of an ordinance or city process. That's all I have in the way of my report. I'd be happy to answer any questions or turn time over to the applicant.
Okay, thank you. We'll go ahead and invite the applicant to come and speak. We are requesting that we keep the presentation this evening to 20 minutes or less if possible.
Thank you. Let me start by way of introduction. My name's David Jeffs. I'm the attorney for the Zobels, and as was indicated, I filed the application on behalf of them to revoke the conditional use permit. The reason it was there's a couple of reasons why this was done and why I think it's appropriate for this.
Sir, could you please talk more into the mic?
Is that better?
Thank you.
Okay, sorry. There's a couple of reasons why I think that the conditional use permit should be revoked. The first of those is that and let me just indicate that this is based on order of what I consider to be importance. And that is the first of those is that the Planning Commission failed to make the findings that are required by the city ordinances. Now, there's actually two city ordinances that apply. One is 14.02.040, which is the general ordinance that's relative to conditional use permits. And then the second and more specific one is 14.34.250, 11H is the part that's in there. And the second of those actually requires that there be specific findings that be made by the Planning Commission before it grant the conditional use permit. The second reason why the conditional use permit should be denied is the applicants were not given proper notice of the June 8th, 2022 Planning Commission meeting. And as a result of that, they didn't know that the Planning Commission had granted the conditional use permit. More significantly, they didn't know that the Planning Commission had granted this conditional use permit in a location other than what they had been informed was the correct location based upon what the Atlas Tower had provided to them. And in fact, it wasn't until November of 2022 when the tower started to go up that they were finally aware that the location had been changed at that point in time. Now, to give you a little bit of additional background relative to this, when the Zobels and the Terrys, who are next door neighbors to each other, were first informed about the neighborhood meeting that was going to occur, and this was a notice that came to them from Atlas Tower itself. They misunderstood. They thought that was a Provo City meeting. They didn't understand completely, but it was actually a neighborhood meeting that they were informed of. They immediately contacted Atlas Tower's representative and had her come to their place, and they talked specifically about the tower and its location. And at that point in time, let's see if I can make this work. There, oh, I went too far, sorry. So this is the same picture that I think you've seen, but to give you a little bit of additional insight in terms of it, they were informed that the location of the tower would be where I think that blue dot is located there. And that was in the vicinity where there were some additional billboards that were already in place prior to the time that the Terrys and the Zobels actually built their home. So that was the location that they were informed by Atlas Tower where it was going to be located. And they were informed at that time as well that the tower would only be a few feet taller than the existing billboards. So on that basis, they weren't concerned about it because it was basically going to be an additional impediment to their view, but not really that much different. And both of those things ended up being not true. Now, the location ended up being changed as a result of what the city said was required based upon the city ordinances. But that wasn't what was initially indicated to them. So there was a notice that went out, and there are actually there are at least three problems with the notice that went out. One is, and let me just, I think if I can get this to work again, if you see the notice that's reflected here, this is the notice that went out. They didn't get it at the time that it went out, but you can see it's the same picture of the location of where the tower was going to be, and it references that the tower was going to be located at 1499 North, 2200 West. Now, we've submitted some materials to the Board of Adjustment that indicate that the property that is actually identified there doesn't have that address. That's not the correct address for that property per what the Utah County records reflect. There's another parcel that's a little bit, I don't know if you can see it, but it's up in, okay, can you do the little portion to further that way, a little up? There you go. That's actually the Jorgensen's piece of property. That piece of property is the one that has that address of 1499 North, 2200 West. So there's an initial defect in terms of the notice because it identifies a piece of property that is inaccurate. It doesn't indicate the correct property. It's curious that this property is right on the border of the north and south neighborhoods. And so the notice that actually went out and that was part of the process for the neighborhood meeting was actually sent to the north neighborhood, not the Grandview South neighborhood. Now, they did get notification of it because that's what prompted them to have the communication with Atlas Tower about the location and why they were informed about it. The most significant problem from my perspective is that neither the Terrys nor the Zobels received that notice. This form that is here was never delivered to them. it was not, and it's not just them that it was not delivered to. There were a whole number of individuals. We've submitted some affidavits or some declarations from a variety of individuals. Not all of them. There's a huge number. You're supposed to do the notice within 500 feet. So it's not just them that didn't get notice, but there are a whole number of people that did not get notice about this particular planning commission meeting. And that's significant when you take into account that the Zobels are the most adjacent, if you will, to this particular location. They're the ones that should have gotten the notice, but they didn't get that notice. And as a result of that, they weren't informed significantly as well. They weren't informed, and this notice does not indicate that there was actually a change in location of the tower. Now, that's something that the city made Atlas Tower aware of. And this is the notification. This is an email that went out to Atlas Tower on June 1st. So this is 7 days before the hearing, the planning commission meeting. And if you look at the last couple of 3 lines of this particular notice that went out, it was a notification to Atlas Tower that says we need to see a new site plan and changes in order to move this permit forward. So the city thought that there had to be a new notice, there had to be a new site plan submitted before they could move forward. Notwithstanding, and then would you please provide the new site plan reflecting this change? Atlas Tower did not produce any new notice, any new site plan at that time. It was not until long after the actual approval of the the conditional use permit that Atlas Tower finally got around to submitting any sort of documentation to the city that identified the specific location. So it's not only that it's not only that the Zobels and the Terrys didn't get notification, which they should have gotten notice so that they could have an opportunity to appear and object and make some notification. But Atlas Tower knew that they had to move this. Atlas Tower was informed by the city that they were going to have to submit a new site plan before, and that's the way it's framed, is before we move forward with the permit. Nonetheless, they proceeded forward with that particular plan. I think that's relevant to the other issue which has been brought up, and that is there's an inherent unfairness to this whole process when they aren't notified, when the Zobels and the Terrys are not notified that there's been a change of location. They're not notified that there's a planning commission meeting, so they don't have the opportunity to appear at that planning commission meeting and to voice their objections relative to that. And they're not aware that the planning commission has granted them the permit has been granted at that alternate location. So they don't have any way to know that they need to move forward with some sort of an appeal. It's inherently unfair to then hold them responsible or hold them liable for not having commenced an appeal sooner because they didn't know that there was anything that they should have done. I think that's the primary notice issue. It has to do with the fact of some generalized unfairness, fact that they were not given a reasonable opportunity. They didn't really have a due process opportunity to file an appeal because they didn't know that there was a change in location. They didn't know that it was moving forward differently than what they had been informed. Okay, now, and there are some criteria that are set out in the ordinance that reflect for general use of conditional use permits about what it is that you're supposed to do in order to be able to have a conditional use permit. And those generally are that it can't be injurious to adjacent property, it can't be a safety issue, can't be a health issue. But this is where it's more significant, and that is that there are some specific requirements that are imposed on the planning commission in terms of their granting of a conditional use permit for a cell phone tower, for what's called a monopole. And these requirements are mandated. It's not just something that that the planning commission should consider. If you read that clause 2 that's in there, it says, in addition to the conditional use standards set forth in 1402-040, that's the one I referred to previously, the planning commission shall make the following findings for any cellular facility subject to a conditional use permit. So now there's 5 criteria that the Planning Commission not only has to consider, but they have to make specific findings that it satisfies those. The first of those is that the proposed structure is compatible with the height and mass of existing buildings and utility structures. I'll show you in a few minutes that that was not complied with. The co-location. Now, item number B that's up there, the co-location of the antenna or other structures in the same vicinity as possible without affecting an antenna transmission or reception. That's not something that the lay public can be familiar with or can have the information. That's a requirement that Atlas would have to have produced in order to be entitled to have the conditional use permit granted. Zobels and Terry's don't know that, but that's the obligation that Atlas would have to produce. But more significantly, the Planning Commission has to consider that information, and they have to make a specific finding to that effect. Item C, that the antenna location blends with the existing vegetation, topography, and buildings. Again, I think I can show you in a few minutes that wasn't done either. The item D is that the location approval of monopoles will not create a detrimental impact to adjoining properties. Again, I'll show you some pictures that will demonstrate that. And then item number 3, again, this is an item that lay people don't have this information. This is a requirement that Atlas Tower had to produce in order to be entitled to get the conditional use permit. And that is they had to show that the location of the cellular facility won't interfere with any existing transmission signals. So B and E are on Atlas, but all of them had to be addressed by the Planning Commission, and the Planning Commission was required to make specific findings relative to that. Now, I didn't add it into the, I didn't produce it as part of a slide, but I produced for you a copy, a transcript of the Planning Commission and the actual minutes of the Planning Commission that occurred on that June 8th day. You can read it over, but there is no reference anywhere in any of that they considered any of those 5 items and made specific findings relative to any of them. And that's what they're mandated to do based on their own ordinance. So then, but this is what you do get. This is the report of action that was submitted. And when you read in the upper second page, upper part, when it talks about the Planning Commission discussion, it is devoid of the satisfaction of those 5 requirements. They do not, the Planning Commission does not indicate that it has gone through and made those 5 findings that it's mandated based upon the ordinance to make. Now that's significant because there's very clear Utah case law. There's a case that came out of Springville. It was called Springville Citizens for a Better Community versus the City of Springville. Big lawsuit that happened between all of those, between both the Springville City as well as a series of people over there. It had to do with, oh no, where'd my case go? There we go. It had to do with a PUD that was approved by a Planning Commission. So it was the same sort of thing. And it went up to the Supreme Court, and the Supreme Court addressed the issue about what is a city permitted, is a Planning Commission permitted to ignore their own ordinances? And as you would expect from the Supreme Court, they said, no way. The Planning Commission is obligated to comply with their ordinance. Now, in that particular circumstance, in the Springville City case, it involved a similar kind of, it wasn't exactly the same language, but it included the same mandatory requirement that the Planning Commission had to go through a mandatory process. The city had established their ordinance, had set out what those mandatory requirements were, and the Planning Commission therefore had to comply with those. It's important because the court in that case, and this is, I don't want to get into all the legalities, but the court had before it the question about whether or not the Planning Commission could, quote, substantially comply. And that was basically, you know, you mostly did it. You didn't do everything perfectly, but you mostly did it. And the Supreme Court said, no, that does not apply. When you have a mandatory provision like this, substantial compliance doesn't apply. You have to comply with whatever the ordinance says. And in fact, the court went on to say that, let me just read, this is pretty significant, I think. It says, The city was not entitled to disregard its mandatory ordinances because the city did not properly comply with the ordinances governing PUD approval. That's what was at stake in that case. We conclude that under Utah Code Annotated, and they quote a section, the city's decision approving the PUD was illegal. So it's not merely a situation in which you have to, you kind of didn't do it. You're in a situation in which because you didn't comply with your own mandatory ordinance, it renders the decision illegal. Now, that's where I think we've got a problem with this situation, because if the Planning Commission does something illegal, and if the Planning Commission doesn't fix it, and if this body doesn't fix it, then what you have had happen is that you now have illegal activity that is permitted to go forward with the city without the fact that it gets corrected. And true enough, it may very well be when Mr. Pepperoni, I'm not sure if I said your name right. I hope I did. Anyway, when he talked about the criteria for overturning and revoking, the biggest problem I have with that is it doesn't include in that list that what the Planning Commission did was illegal. But that ought to be one of the simple bases on which you can overturn and correct previous action. If an entity, if a group, if a planning commission, whomever it is, has done something illegal, that should be something that the planning commission can fix, or in this body can fix. And that's the circumstance that we're in right now. That's the reason why there was a request for there to be a revocation of the conditional use permit, because the failure of the Planning Commission to comply with the city's own ordinances requiring specific findings of fact to be made before the conditional use permit was granted, that's illegal activity. And if this body doesn't overturn it, then what you've had happen is the city has been permitted to engage in illegal activity. And you're basically telling the citizens, we're sorry, even though we engaged in illegal activity, there's no way you can get it fixed because you didn't appeal within a time, recognizing again that they didn't appeal because they didn't know about it. So that's on that basis that we think it's significant. And this body ought to take the bull by the horns and ought to fix the problem of saying, Planning Commission, you did it wrong. It's illegal what you did, and we're going to fix it because we're going to revoke that particular action. I know the timer thing came up, so I'm probably running out of time. Let me run through. Let me just show you quickly some of the things. Now, recognize those earlier criteria. It's supposed to be, I can't remember what the exact wording was, but it's supposed to be consistent with the existing mass and height of surrounding buildings. This is the construction of the tower when it's going on. And you can see it is this is from the Zobel's home. This is way higher than anything around there. Here's a tree that's looking from the north, same thing. There's no other vegetation around there that is consistent with. They attempted to try and disguise it by characterizing it as a pine tree, but there's no other pine trees around there either. That didn't work. Here's some other photographs. You can see this is from the freeway side, and you can see that the tree is clearly not consistent with the height or the mass of the surrounding buildings, structures, or the vegetation. I'm going to quickly go through some of these because I don't want to run out of time. Here's another picture of it. And actually in this picture, you can see the billboards that were south. That's the area where they thought it was going to be. And I don't know what they were thinking when they told them that it wouldn't be only a few feet higher than the billboard, because it's pretty clear it's not a few feet taller. It's a lot taller than it was. And then one of the other criteria is what the impact is on the adjoining property. Now, this is their house viewed from the east. They've got a very nice house. They have swimming pool. They have courts. And here is now the view that occurs from their house. You can see that it is a dramatic and impairing obstruction that has occurred to their property. It has clearly injured their property by virtue of the fact that this cell phone tower jumps up right in front of everything. You can see it from other areas within the home. These are from windows from the porch and the kitchen. This is from their upper deck. You can see how enormous the impact is on the visibility of this particular property. It is clearly well beyond what was intended to be done based on your ordinance, to be compatible with the existing structures, the existing vegetation, and the mass and height of those. Here's the last picture. Let me just conclude by saying, again, I go back to what I said before. If this was just a situation in which the Zobels missed out on their opportunity to come to a meeting because they didn't get a notice and they didn't like how this looked, that would still be sad. That would still be wrong. They should be given appropriate notice. They should be having the opportunity to come and voice their objection. But when you couple that with the idea that the Planning Commission clearly violated their own ordinance, this body should just not countenance that. This body should not permit that to go forward. This body should rectify the problem by revoking that conditional use permit because it's an illegal act. That's what the Springville case said. I think it's appropriate for this body to simply take the appropriate action and to revoke the conditional use permit so that the problem of an illegal approval can be corrected. I don't know if you have any questions. I'm happy to answer. If you do.
Anyone from the board have questions for the applicant before we representative from Atlas speak?
Okay.
Thank you.
Hello, my name is Jay Springer. I'm representing Atlas Towers, the conditional use permit holder. Let's see. Okay, great. So just kind of outline overview. A lot of this is going to be repetitive, so I'll try to go quickly through it. This is an 80-foot cell tower, which is where the 160-foot double height goes for, where that length restriction works. And it has coniferous type branches. That was part of the conditions imposed on this by the Planning Commission. It is a conditional use, as discussed before, and the tower is built and operated. So as kind of a timeline, for months prior to April 2022, Atlas was working with the city staff, coordinating, working with the Grandview neighborhood, and preparing to submit the application. Late April, they determined when the hearing would be, when the neighborhood meeting would be. And that would be May 10th. Atlas mailed notices out for that neighborhood meeting, and Mrs. Zobel contacted Atlas, who then met with them at their house as they discussed earlier. At the actual community meeting that people had notice of, only one participant was there, and that was the chair of the Grandview North neighborhood. So that was the first opportunity that people had to provide comments. On May 23rd, Atlas received notice from Provo City. They were setting the hearing for June 8th, and that they had received additional comments from other members of the public. This is a depiction of all of the mailings that went out for the neighborhood meeting. That was Atlas's responsibility. Late May, Provo mails out the notices. Provo City has represented it in public meetings that happened according to their normal process. Atlas had nothing to do with that. June 1, after those notices were mailed, Provo City informed Atlas of the need to move the cell tower to comply with technical requirements of the ordinance. Then late May, early June, Provo City posts and publishes the notices. There are several places that this occurs. The city website, the Utah Public Notice website, all sorts of public places. I don't know about social media, but maybe there was something there too. Then there's the public hearing. There were several participants. I understand, I mean, the transcript that was submitted was dozens of pages long. This was not a short hearing. It was over an hour long. The public was there. Then the city planning commission participated and imposed additional requirements beyond what was included in the staff report, and then issued the conditional use permit. From June to November, technical work, final approvals, and then construction. Then in December, we get the request for revocation. January is the 2-hour-long planning commission hearing at which the revocation request is denied. And then in February, we get the appeal of that denial, which is why we're here today. So I know as much as I don't want to talk about this, it has been raised, so I'm going to respond. The record of decision or record of action that is provided clearly says the record of action specifically includes facts of the case, analysis, conclusions, and recommendations outlined in the staff report, including that it meets all of those 5 provisions that the applicant is so concerned about. It is specific. It references the ordinances. It was included in the staff report. This is not something that was sprung at the last minute without consideration, and that hardly rises to the level of an illegal action. And then there were, again, this was part of the staff report before the planning commission meeting that it had to be moved. This was before the planning commission. This wasn't something that happened behind closed doors and nobody had notice of. It was part of what happened in getting ready for this meeting. So the revocation request itself, to the extent that it's trying to appeal the issuance of the conditional use permit, it's untimely. The deadline for that was back in July of last year. And it's improper in that it doesn't relate to any of the 6 factors that are required for overturning and revocating or revoking a conditional use permit. So these are the 6 factors. And everybody's kind of thrown this up there. There's a couple of things I want to highlight. This is an optional action. It may be modified or revoked. It may be modified. So even if all of these things were found, the action could be nothing and it would still be proper. The action could be modification and it would still be proper. It does not mandate revocation. So the first one is misrepresentation of fraud, and there's simply no evidence of that. I'll raise again, the burden is on the applicant to show that these things happened. So the city was fully informed. There were no surprises. The city had opportunity and did impose additional requirements. 3 of the factors for revocation are basically related to whether they're doing what they're supposed to under the permit. So that's B, C, and F. Was it not being exercised? Clearly it is. Let's see. Has it ceased or suspended for 6 months? No. 4 is the conditions have not been complied with. And again, here, all the conditions that have been issued have been complied with. There are coniferous branches. It is in the right location, and it is doing as much as it can to keep the natural vegetation, which was one of the other requirements that was imposed by the Planning Commission. Let's see. So, let's see. Okay, the conditions haven't been complied with. And then, okay. So then the last one is that that's the one that's related to the use. So the use is detrimental to the health, safety, or general welfare. And this is where it talks about the property. And market value is not a factor that can be considered for revocation. It simply isn't. And that's consistent with Utah law and property rights across the board, including what's already been stated before by the staff. There is no right to a view corridor in Utah. You don't have a property right for a good view. It's just not how things work. And then the last one, the use hasn't been materially altered or expanded from what it was granted. So those are the 6 factors that the Planning Commission considered, found that none of them had been met, and that they didn't even have the option to modify or revoke. So with that, there's no basis for overturning it. Let's see. And so that is the PROVO Municipal Code, section 1405030, subsection 4, which places the burden squarely on the applicant, and they haven't met these 6 factors. Additional note on this, if we were going to go back and reconsider every application, every conditional use, everything out there, because somebody didn't get notice and complained about it later, we would be looking at a huge burden on the city staff. That would just be unreasonable, and that's why things are set up the way they are. A couple of final general notes. Again, this is not coming from an appeal of the issuance of the conditional use permit. They have 30 days from the day that decision is final, which would have been the June 8th hearing. And this is applicable to any person who had actual notice of the pending land use decision. This is not actual notice of the meeting or a public hearing. This is, did you know there was a cell tower going up on that property? Yes, they did. That is absolute. That is Utah law. That time has run. And 5 months later, 5.5 months later, they decide to appeal. So a couple of final notes. Hearings on conditional use permits are not required or even encouraged by Utah law. Approval of a conditional use permit is mandatory if reasonable conditions are proposed or can be imposed, and those conditions do not have to require elimination of the detrimental effects. They just have to reasonably mitigate. This is Utah law. It is clearly established. And the reality is the reason many cities don't have hearings on conditional use permits is because it gives a false sense of power when the planning commission really doesn't have it. You can show up, you can complain, but if reasonable conditions are imposed, they have to approve it. That is how it works. And that's, that's my presentation. So I think there are some concerns with trying to go back in time that really are not equitable to Atlas or the process itself. If you have any questions, I'm happy to answer.
Any questions from the board?
Okay, thank you.
We have a chair present. So before we open up to public comment generally, if the neighborhood chair would like to, make a brief comment, now is the time to. If you would introduce yourself.
Yes, my name is Mindy Jefferson, and I was the neighborhood chair of the Grandview South neighborhood until things recently changed in January. And now Beth Hedengren and I are on the current District 4 board. This monopole has always been located in Grandview South, yet not until last month were any of the notices labeled Grandview South. Up until last month, they were always labeled Grandview North. And it frustrates me that the address listed was the residential address of the property owner, which is very clearly in Grandview North. When I received notice last year, I looked up the address and verified, yes, it is in Grandview North neighborhood. I do not need to take action as I am the Grandview South chair, as I was at the time. What is most frustrating to me is that the change the change requested by the city, and that Atlas Tower should have presented a new site plan before the June 8th meeting, and that information should have been shared with residents. And it is
In Grandview South.
Most especially in Grandview South, seeing that the original location was most definitely in Grandview South, and the actual location also is in Grandview South.
Yeah, and evidently, those postcards did not reach the people that needed to know about it. And so it makes it very difficult for them to respond to it. So there seems to be a really important flaw in the process of this going forward. Oh, I'm Beth Hedengren, Grandview South neighborhood.
I'm Keith Morey. I'm the Assistant Director of Development Services, but I was asked to read this letter for Richard Jossie because he couldn't be here tonight. So his letter says, board members, I'm not able to attend the meeting tonight in person, and it doesn't appear that there is an option to give comments online. I was the neighborhood chair for the Grandview North neighborhood, and we held the hearing on this poll. Only 2 people attended, myself and a citizen from the South neighborhood. We also had Councilmember McKay in attendance. The meeting was properly noticed as instructed by Karen Tapahe, who worked in the council office at the time. Thank you for your service to Provo, Richard.
If members of the general public would now like to take a brief moment to address, we ask that just the board, we ask people keep their comments to approximately 2 minutes.
Chair Board, thank you for your service. Appreciate it. Been on the other side several times, and I think I prefer that side. I'm a little nervous on this side. So, but my name's Travis Hoban. I'm at 1416 North, 2100 West. I'm not here today as a council member. I'm just here as private citizen member of the Grandview South neighborhood. I was not involved in the process, have anything to do with the monopole decision. Have no inside knowledge or involvement there, and also not involved in any of the legal process either. So with those disclaimers out of the way, I guess I don't know if this is about a fake tree. I mean, it's big and it's ugly and I got to see it every morning, but same thing with my dad bod, and I haven't done anything about that. You know, I get used to it, right? This is, I think to me, this is about 2 things: trust and least harm. And so I wrote my words down, try to stay on track here. Anybody who watches the council meetings know I have trouble with that. So I think, to me, the question today is, will more harm be done if the people of Provo feel they can't trust their city government, or will more harm be done by requiring an out-of-state company to remove a big fake tree? Yes, it will be a hassle for Atlas Communications, but in my mind, that pales in comparison to the importance of reassuring the people of Provo that they can trust the information provided by their city and trust the city to follow their code and processes in regards to zoning and land use and conditional permits, etc. A big piece of that trust has been lost with the process of approving this monopole. Losing trust in government is a slippery slope that we here in Provo don't want to go down. We can restore some of that trust today. I believe the least harm to the people of Provo long-term is to ensure they can trust the information provided by the city, and that they can trust the city will be held accountable if they do not provide accurate information and follow their own code and policies and procedures. So again, what is the least harm done? I ask the company to remove the fake tree and deal with it, or harm the trust that the people of Provo place in their city and deal with the long-term implications of a lost trust. Thank you again for your service.
So as members of the public come up, if you would just state your name and address and make a comment.
Okay. Thank you. My name is Doug Gale. I live on 1319 Grand Avenue, Provo, Utah. And I used to be the neighborhood chair of the Grandview South neighborhood. So I am that mysterious person they keep talking about that attended the meeting. So I attended that Atlas meeting about the cell phone tower because I was doing my due diligence to see what the tower was about. I asked all the questions. I guess you could go back and look at the transcript because it's recorded about the tower. And at that point, the tower location was as stated by Attorney Jeffs. It was down by the billboard, kind of quite a bit further south, so a little less intrusive into the neighborhood. So I asked all the questions. I was interested as a cell phone user. Will it help? I can say it helps. My phone works better now. But I also asked all the other questions about hazards and et cetera, those items that they listed, A, B, C, D, whatever. And I was assured that it met those requirements, and I was satisfied with Atlas' description. I also asked about objections, and at that point, there were no objections to that. So
Can I ask who you asked if there were objections and how you made that request?
how I made that request?
Yeah.
I just asked at the Atlas meeting. And actually, the reason I came down to this meeting today was because having served on a neighborhood committee and tirelessly trying to get the information out, it's very difficult. And you often work tirelessly to get the information out. And then often you make a decision and then somebody objects because they haven't been informed, but honestly, they haven't spent the time. It's very frustrating as a neighborhood chair to see that happen. That's why I wanted to come to the meeting to support the tower. However, I've now found out the objections to the tower. I understand why they're objecting to it because it was moved. I received a notification from Atlas about that meeting. I attended it, and I received this notice about your hearing tonight. Those are the only notices that I've received. So I was in favor of it as it was located, but to this point, until I got this little notice, I didn't know what had happened at the tower was located differently. I see the tower. I wondered what the Zobels would think about it. I thought, well, they must have known about this because it's right there. I can understand. It's quite evident to them. But anyway, I'm the mysterious person that went to the meetings, but I wasn't informed of all the meetings. Okay.
Thank you.
May I ask a quick question, sir? You said you received the notice from Atlas and the notice from the city.
I received a notice from Atlas about the meeting that they talked about, where they described the tower and what they're doing, and where you could voice objections. And the other notice I received is this one about the hearing tonight.
Oh, for tonight.
And I pay pretty close to the mail. I look at it to see, does it apply to me? Does it apply to my neighborhood? Even not serving as a neighborhood member now, I want to be involved and try and understand what's going on. So I didn't attend any other meetings, but I didn't know there were any other meetings.
Okay.
I could have given some input because it's obviously located differently than when I went to the Atlas Tower meeting. Does that make sense?
Sure. Thank you.
Yeah.
Are there any other members of the public that would like to statement?
I was just wondering if there would be an opportunity to rebut something that was said.
During our deliberation period, we might be able to invite you to.
My name's Marilee Terry, live at 1495 North 2100 West. The part of where the tower is located is behind our home. And I want to just clarify one thing about the fact that we did not receive notice for that meeting, but we also had a private meeting with Carrie Woolner from Atlas Tower, the representative who sent out the Atlas Tower notices. And she met with us in our home, stated where the cell phone tower would be and how tall it would be and such. We kind of joked about the billboard that was already there when we built our home. It's not a problem. She said it wasn't going to be much higher than that. It's actually twice the height of that. So we were actually going off what her word was with Atlas Tower. She met with us personally and my parents. And so we didn't even think we had to go on a website for Utah, for Provo. And we were trying to work with Atlas Tower. We knew if we weren't trying to be bad neighbors, we were trying to do our due diligence and be a good neighbor and say, okay, as long as this is where it's at, shouldn't be a problem. So we were not informed at all about the change in site at all. We did not get notice for that meeting. Apparently it went out, what they said was 1,000 people, 78 neighbors. We personally went around and got depositions, actual states. They were held up in a court that stated those people did not receive notice. President Gale just told you he didn't get notice for that meeting. Our neighbor across the street, Mr. Hoban, didn't get that meeting. So for what it is, that's what it is.
Wait, stay. I'm Richard Terry.
Marilee's husband. We live just south of the Zobels. You saw the pictures of the two homes. We're in the gray one that was just south. We welcomed her into our home. She was very, very nice, very upfront, we thought, with everything. We just felt deceived. You know, she made it sound like it wasn't going to be much bigger than anything around there. She looked at the existing trees and said, oh, they won't be much higher than those. The trees that are now gone to put the tower in, they took those trees out. So it's just disappointing. We were just misled. I truly believe we felt good about it until all of this kind of happened. And then one day in November, it said the building process was from June to November. We didn't see anything until November. And then all of a sudden they started building the tower where it wasn't supposed to be. That's where we were shocked. We didn't know anything until that point. And so it's just disappointing.
Thank you. Anyone else before we close the public comment?
Sorry, I just.
Keep it to the same kind of 2-3 minutes. That'd be great.
Yeah, I'll make sure I'm at the mic, right? I just wanted to make a clarity in terms of the modification or revocation statute or ordinance that was shown by council for Atlas Tower. He kind of skipped over it, but if you look at item number E that's listed in that section, I don't know if it's still up, but it's 14.02.070. And then it's paragraph 4E. In terms of the grounds for that, it does authorize the Planning Commission as one of the means for revocation or modification that the use is detrimental to the health, safety, or general welfare of persons residing in the vicinity or injurious to the property. It doesn't include a definition of what it means to be injurious to the property. It does say that a change in market value isn't considered to be an injury to the property, but that doesn't alter the fact that there has been, in fact, injury to the property. And it may very well be that there isn't a legal entitlement to a view, but that doesn't alter the fact that based on the obstruction of the view, there has in fact been an injury to the property. So there is actually an ordinance-based reason on which the Planning Commission could have revoked the conditional use permit based upon that ordinance that's there. And again, that's for this body to then address the appeal as to whether or not that should have happened. Again, based on what I said before, I think if you're going to allow illegal decisions by a planning commission to go unassailed, that is a serious problem that I think needs to be addressed by the Board of Adjustment. Thank you.
Seeing no other public comments, I'll go ahead and close the public and allow us as a board to begin our deliberate.
I have a question for Atlas, because can't vote on this. I'm not going to deliberate with them, but my recollection is that we had asked Atlas to preserve the vegetation in that area, and to the extent that it had to be removed, that they would replace it. And I understand that we are still in the same winter season. So is there an intention to replant trees around where they were before?
This might be a better question for Mike Powers. I know it is something that has been discussed. I don't know the current status of it, though.
Okay.
Mike Powers is a principal of Atlas.
I believe there was a land. My name is Michael Powers. I work for Atlas Tower, and specific to your question, I would prefer to refer to the record, but I know the staff had specific requirements for the building of the site and any landscaping plans that were required after the fact. There was absolutely discussion about the need to cut down some of those trees that were quite overgrown, and some were actually dead. That was reviewed by the Planning Commission that approved the actual conditional use permit.
So my signature is the one that's on that approval
Yes.
from the Planning Commission. And I do remember that and I believe it's in the report of action for that particular thing, that vegetation was to be replaced.
And absolutely that will happen then. I just didn't want to speak over a documentation or facts that were already within the record, because I don't have those in front of me. But if those are requirements, they actually absolutely will happen. We regularly vegetate our sites as required by code, and sometimes just simply by request of neighbors. Obviously, none of that work could logically be done up until perhaps another month before there is a planting season. So if those were requirements of that particular approval, then it absolutely will be done. And I just want to say, just for the record, I was in the background of this project for a long time, working with Carrie in the office and aware of all of the communications. There was extensive back and forth with the staff. At all times, Atlas represented the truth and the facts as they knew them at all times. And I want to dovetail that comment into the disparagement of Carrie Woolner. When Carrie Woolner met with the neighbors, she gave her contemporaneous understanding of what would be approved. She didn't at that time guarantee that the tower wouldn't be removed or not approved or otherwise modified. She didn't have any knowledge of that at that time. Carrie Woolner is a person I've known for more than 20 years. She would not intentionally misrepresent or produce a falsehood in order to move a project like this forward. And it's just irking me that we're being characterized as a company without morals or honesty. The fact of the matter is, Atlas Tower went through the process that was given to us, that was designed by the government of this city, and we followed every step as best, well, to a T in terms of complying with all of those decisions. And quite frankly, what I see is that the Planning Commission could have, if they chose to, they could have renoticed when they decided to approve the tower in a different location than what had been noticed. That nothing would have stopped them from continuing that hearing, renoticing, and then causing Atlas to come back at a later time. They didn't do that. Atlas didn't have any control over that. That's not a process that we made. We just followed it. And as a result, we have an approval, which is quite legal, as our attorney beside me has explained. And so I just wanted to make that comment. We are honest people. We are ethical people. We've worked in Salt Lake City for at least 15 years now with other cities, Saratoga Springs, all the way from Woods Cross, all the way to Provo and beyond. And we are not people that tried to misrepresent anything to anyone in the act or commission of trying to get an approval from a governmental agency.
I do appreciate your comment, but that's beyond the scope of what I asked. So thank you.
I just felt compelled to say that. It's important to me. Thank you.
Thank you.
I have the verbatim language of that if you want. So from the report of action, reading verbatim, the natural vegetation on the site should be preserved as much as possible and be replaced as needed.
Thank you. Other members of the board, thoughts, questions?
Sure. So I've been on the other side of this too. I've been a neighborhood chair before, and I've gone before a planning commission and said, hey, we don't want this in our neighborhood. But I think even if all the noticing steps had gone perfectly and every single person was able to give their input who was affected in any way and all by this, I feel like the planning commission still would have had to approve this project, except, maybe the conditions on the conditional use permit would be different. But I feel like it would have been approved anyways. So I don't see a place for us to overturn their what we're being asked to do, to overturn their petition for a revocation that was denied.
I hear what you're saying and I agree. I've been neighborhood chair and active in my neighborhood for many, many years. I've been part of that process, and I've also served on the planning commission, and I've been part of meetings where an applicant has come, with their project proposal, and they come with it being one way, but due to things that the planning commission comes up with, like vegetation, for example, the project gets tweaked, and so they end up making changes based on things that are brought up, or items in the code that are brought up at the meeting. So you may walk in with one project being this way, but walk out with changes having been made. So I understand both sides of the issue. As I reread the item tonight that we're here for, and I apologize for my sunglasses, but the lights bother me. We're being asked to decide whether or not the let me find it, I'm sorry. Whether or not the planning commission I want to find it and read it exactly. If somebody finds it before I do, help me read it. Well, anyways, whether or not they made any mistakes based on the code. And I'm not, based on what I've read and what I've heard here tonight, I don't believe that we're able to overturn their decision that they made. That is, I'm not able to come up with any findings to justify that.
Really sensitive to, invested in personally in some of the comments that were made regarding fairness, trust, transparent, really, really navigable by Henry that the city serves. And I also not sure that I feel like I have the levers or the scope to addressing those issues, such as reasonable notice. So, and I think a lot of this comes down to this concept, for me at least, word may. There's discretionary authority that the commission has, and I don't know that I feel that I can substitute. We can substitute our view for theirs. In areas where they have the breadth to be able to or not to find. It sounds like, I mean, and because there's three of us who are actually voting members of the board tonight, we do need to be unanimous. It does sound like we're all kind of generally in aligned. Does that mean that we're prepared to
I think so. I do want to say one other thing too. I know that people are frustrated with the process and the noticing and all that too. And even if we were to take a stand against how things have been done in the past, the city has redone the whole process since in the last year since this, with the new neighborhood executive boards and getting rid of the traditional neighborhood chairs. So I'm not even sure what kind of impact a protest vote like that would have for us, because the process has changed since then.
I mean, I often kind of find myself in these positions where could the process have run better? Yeah. Would the outcome,
I'd like to make one other observation. I noticed that Atlas sent out notices to every household within 1,000 feet, but city, their practice is to send out notices to everybody within 500 feet. And so most of the properties in the Grandview neighborhood are on much larger lots and are larger. And I wonder what difference that makes in how many people receive notices from Atlas versus how many from the city, and how much that played into the fact people feeling like they didn't receive notices. Maybe they did from Atlas, but didn't because of that 500-foot difference. I don't know the answer to that. I'm just throwing it out there.
well, either one of you be willing to
Yes, I move that we deny David Jeff's request for an appeal of an administrative decision by the Planning Commission for denial of a revocation of a conditional use permit for a monopole tower located at 1499 North, 2200 West in the agricultural A1 zone in the Grandview South and North neighborhoods.
a finding that we'd like to attach to that. I'd be comfortable with language even of just finding that the Planning Commission acted within their pretty. Just adding that, we find that the Planning Commission acted within their rights and pretty in making.
I will second.
Okay, then if each of you would names, well, I'll start the voting. Andrew Rennick, I vote.
Maria Wyndon, aye.
Eric Chase, aye.
That it has been decided we have denied the anyone wants to kind of, isn't interesting for kind of item number 2, now might be kind of an opportunity to, otherwise we'll move directly into. All right, well, people are shuffling. I'm going to go ahead and read item number 2 into the record. We have Brian Gibson is appealing a staff determination of legal use of a 2-family dwelling for the property at 129, 131 East, 300 North in the residential conservation, I believe. Let me turn the time to staff to make the report.
All right, thank you very much. Okay, here's the property that staff has reviewed when we received the appeal. Staff has reviewed this property and determined that the legal use of the property is a 2-family dwelling. There's 4 parking spaces, so each unit would be for 1 family or 3 singles in those 2 units. A reasonable accommodation was granted in 2008 for increased occupancy on this property. And I'll just kind of describe a little bit what a reasonable accommodation is. As from time to time, the city is receiving those requests and able to grant them where they are needed. A reasonable accommodation is a temporary waiver of rules or policies to help persons with a disability to have equal opportunity to use and enjoy a dwelling. These reasonable accommodations are issued for residents in the city that have a disability, and they don't run with the land. So this reasonable accommodation would apply to the person or persons in whom it's granted. And not continue on to subsequent property owners on the property. And so on this property, it was in May of 2008 when the reasonable accommodation was granted, and the termination of it was based off of when one of the children that were named in the reasonable accommodation moved out. That's when the reasonable accommodation would terminate. And so it states in there that at that point, one of the units would then have to encompass a certain area of the home, and the other unit would encompass another area of the home. And that would make up those 2 units at that point. And that the 3rd kitchen that was permitted during the reasonable accommodation would no longer be permitted. So there would only be 1 kitchen in each of the 2 units and the 3rd kitchen removed. And like I stated earlier, it states very clearly in this reasonable accommodation that it's not transferable to other persons. And it states clearly in there as well that it shall not run with the land, meaning it won't continue on to a new property owner. And so staff, with that reasonable accommodation that's included in your staff report, determined that the property is only a single family or a 2-family property with 2 kitchens permitted. And in the staff report, there's a zone verification that our zoning division compiled and sent to the applicant stating those things. And then the applicant is appealing that decision by staff that it's something other than the 2-family dwelling. And so they're claiming that the 3rd kitchen should be able to remain, and it should be able to be 3 units. And so staff, in reviewing this applicant's appeal letters, doesn't see that they're able to convey anything that shows that staff has erred in this, and that's, I guess, your job tonight as well to make that determination. So staff recommends that the Board of Adjustment affirm staff's decision of a two-family dwelling at this location. I'd be happy to answer any questions that you'd have for staff.
Does anyone have questions for staff at this time?
At this time.
I just want to verify for the record that when this property is purchased, that this would have come up on a title search, correct?
Yeah, that's correct. So the reasonable accommodations are recorded to the title of the property. So when someone's doing their due diligence and doing a title search, they would have access to those recorded documents on the title.
Okay, thank you.
When the reasonable accommodation was issued, was there already a third kitchen, or did they add it afterwards?
My understanding is that the reasonable accommodation allowed that third kitchen to be permitted. I can't say whether or not it was there prior. My understanding is that it was just a two-family, one kitchen in each unit, and then as part of that, they were able to add that third kitchen. But I don't know all the specifics of what that negotiation in coming up with the reasonable accommodation entailed. I don't have all that information.
Okay.
The applicant or their representative like to?
Good evening. First of all, I'd like to say I appreciate your willingness to hear my case, and I'm grateful for your service to the community and the city of Provo. In my mind, this is precisely the reason why there is a board of adjustment and why it exists and why it's crucial. It'll quickly become apparent I'm not a lawyer. I don't know if that's a plus or a minus, but I will do my best. I'm just a proud member of the Provo community and a landlord. Since moving to Provo 5 years ago, I've really enjoyed being a landlord, in particular, providing safe, clean, affordable housing for young married couples. And that's why when spending the money to come present my case was an easy choice to make for me. The city has asked me to remove a kitchen from a duplex with an attached studio apartment that I own. I won't review the address. And my request is that it be seen as a 3-unit property or for an accommodation to be made similar to the one that was already made to keep the kitchen intact. I'm just going to briefly go through my arguments and then delve a little deeper. I believe I should be able to keep the kitchen for the following 6 reasons. 1, there's a precedent and long-running history of the city allowing a kitchen in the basement unit of this duplex. There has never been nor would be any negative impacts to the city or community by allowing the kitchen. There are adjacent properties in the same multi-use RZ zone that have both multiple units and kitchens in every unit. The map showed a large apartment complex immediately adjacent to the property. We have not yet been able to find documentation that shows the current use of the property is not the legal use of the property prior to the April 2nd, 2002 date when the RC zone was created. Since I wrote these arguments, my request for further documentation was denied by the city because I was interested in knowing when the studio apartment was added to the back of the duplex, which by definition in my mind is a 2-unit dwelling. Allowing the kitchen does not conflict with the stated purpose of the RC zone. And perhaps most importantly, the existence of the kitchen adds value to the community by creating safe, affordable housing for young married couples. So to the first point, there's a precedent and long-running history of the city allowing a kitchen in the basement unit of the duplex. In 2008, the city granted a reasonable accommodation to the owners at that time, James and Frida Garrett. This allowed for them to have a kitchen in the basement. From 2008 to 2018, when the Garretts sold the property to me, there was a kitchen in the basement unit of the duplex. And during that time, there was no negative impact on the surrounding community as a result of the kitchen. Point 2, there's never been or would be any negative impact to the city or community by allowing the kitchen. Having a kitchen in the basement of the duplex doesn't add any additional occupancy to the property. If I had to remove the kitchen, the occupancy would essentially remain the same. So there's no impact in terms of occupancy, whether the kitchen is there or not. Also, there's ample parking off the street for the tenants to occupy the basement of the duplex. They have a garage parking and a long driveway for them to park in. So there's no impact in terms of parking whatsoever. They currently park in the garage space that comes with their rent. And particularly relevant to the two large multi-unit apartments next to the property, there's no impact. There are adjacent properties in the same multi-use RC zone that have both multiple units. For example, the Stonebridge 2 complex at 151 East, 300 North has 15 units. Bountiful Court complex at 185 East, 300 North has 39 units, and each of those units has a kitchen. And my understanding is the reason why that is permitted is because that was the legal use prior to the zone, the RC zone starting in 2002. But like I said, there's no documentation, even though I've requested it, to establish what the legal use of my property was prior to 2002. And if there were, then I imagine I would be afforded the same opportunity that the owners of the apartment complexes were afforded, which is to continue that use with the new zone. And that's my fourth point. The city has denied my request for documentation regarding the building of the studio apartment. I don't know if they just did not have records, but they denied the request because I was curious to see if there was a permit for the creation of the studio apartment on the back, which was relevant. It's possible, if not probable, that studio apartment was built prior to April 2nd, 2002, and was intended as a third unit and was legal at the time. I feel like we really don't know. And what I'm saying is, in the absence of proof otherwise, the kitchen should be allowed due to the precedent of it being allowed in the past, the kitchen having no negative impact on the community, and in fact, there's many kitchens and units nearby. My fifth point is allowing the kitchen does not conflict with the stated purpose of the RC zone. And like I say, I'm no lawyer, but I'm going to quote from that. It says, the original intent of establishing the RC zone was to encourage conservation of existing housing. Allowing the kitchen doesn't threaten, alter, add to, or change existing housing at the present time in any way. And it doesn't threaten the housing that existed prior to the creation of the RC zone in April 2002. And finally, and this is what I'm most passionate about, the existence of the kitchen adds value to the community by creating safe, affordable housing for young married couples. And I included a for better or worse, who this affects most is my current tenants. One of whom is here. I included a letter from them. The people most affected by removing the kitchen are my current tenants, Jake and Daishan. Removing the kitchen affects them immediately, but all other young married couples that I'm likely to rent to in the future. Safe, affordable housing for Provo's many young married couples is in short supply and very competitive, and the rents are very high. The competition for available housing leads to higher rents, obviously. The average rent for a two-bedroom apartment in Provo is about $1,695. There's a range there, from probably $1,200 to $1,600. I charge $925. So removing the kitchen makes one less place that a young couple trying to get a solid footing in life can live in safety and comfort. So in conclusion, the city of Provo has previously allowed a kitchen on the property for a decade, essentially. And there's been no negative effects on the community. There wouldn't be any harmful impact in the future either. And there are already large multi-unit complexes with kitchens immediately adjacent to the property. Allowing for a single kitchen in a multi-use zone doesn't contradict the stated purpose of the zone when it was created. In fact, allowing one single kitchen in a mixed-use zone would actually add value to the community by giving a young married couple in the community a safe and affordable place to live. Thank you.
Does the board have any questions for the applicant?
I have one.
Sure.
So are there currently 3 couples living on the property? Is that right?
There have been at times 3 couples. Currently we have a couple in the basement, 2 single women. I mean, it's in the duplex. Mm-hmm. There's 2 single women in the top floor, a married couple in the basement, and a single person in the back, but at various times, there's been married couples living in all 3 spaces.
Okay.
Yeah.
When did you purchase the property?
So I bought it in 2018 and I bought it from the original owners. And I don't know if it's relevant, but the accommodation, which I became aware of recently and understood, it was so their son could live there. When I bought it, their son wasn't living in the basement and they were renting it out. And my assumption, as erroneous as it might have been, was that, and I had to continue that lease when I bought it. And my assumption, as faulty as it might have been, was that that type of use would be permitted to continue.
So did you go through a title company?
I must have. Yeah. I wasn't aware of the legality of how of the accommodation when I purchased it. And that is perhaps on me, I suppose, or the title company did not bring it to my attention, if that's how I should have been made aware of it.
Okay.
Yeah.
All right. Thank you.
Yeah.
I do have one.
Sure.
Have you approached the city about getting the zone changed?
So I had a number of conversations with my compliance officer and about it's a very large zone is my understanding, and multi-use. And what I was led to understand was this was the best recourse rather than changing and that'd be something I'd be willing to pursue, or what I also might be interested in, perhaps you can educate me, is how I could get a similar accommodation to what was I would love to have it run with the land, but I know that if that's not in the cards, it's not in the cards. But yeah, so we discussed that. I had a number of conversations with my compliance officer, because this was all very new to me, with my compliance officers about that possibility, but it didn't seem like something that was practical, I guess. I don't know. Can you change the zone just for one unit? I'm not sure.
The Planning Commission has done that for parcels in the past.
Oh, okay. Yeah.
So I don't know how the city approaches that, but I just know that as the Planning Commission, we did hear some of those, and so that does seem like an
option.
reasonable option to go through. And if that were the case, would we want to? Do we table this? Do we make a decision? I'm kind of new to the Board of Adjustment, so I don't know what the practice is in those situations.
I don't know. I was just going to ask, do you have 6 off-street parking spaces?
So the way I have a two-car garage, and so the tenants that live, the tenants, the 2 people that live in the upstairs part of the duplex park on the street. Everyone else has a garage or a driveway to park in.
You can't count on-street parking as your parking.
Okay. That's just how the parking breaks down. Yeah.
Yeah, you have, in order to have a duplex, triplex, fourplex, whatever, you have to provide all the parking on the property.
Okay. I could probably do that then, if that was a requirement of
You can't pave all the property.
No, I wouldn't pave it. There's ample parking on the property, because there's a garage and then a long driveway that runs down the side of the property where people could park if that was the issue.
I think legally you can't have a car behind another car on a permanent basis, because it's
have tandem parking, but only so much of it. No, all of the I'm split on this. But Where's Dustin? Hi, Dustin. Have you had a conversation with Mr. Gibson about, is there any room in the code to, is this a possibility, or is this just strictly, is it strictly, would we be steering him in the wrong direction if we encouraged him to go before the planning commission and see if he could get a variance or any such a thing? Or does the buck stop here?
Yeah, we would be happy as staff to meet with him and go over his options. It sounds like he's been working with our zoning division, but planning could sit down with him and see what potential there is for a rezone or something like that. We'd be happy to have those discussions, but yeah, as far as tonight goes, we're not looking at finding, is there another solution? Those are something we can handle later. Today, we're just handling the appeal decision only. In that is staff's decision correct or not? So we wouldn't need to continue it to see if there's another option. That would just be something that we would do later, and there may or may not be, depending on the configuration of the property and all of the variables that go with the rezone. So that would be a separate thing.
I'm not trying to pass the buck. I'm just, seeing it's already been used as a triplex. I'm maybe using the term wrong because it hasn't been legally determined a triplex. So I don't want to, I'm not trying to give false hope here, but are we going in the right direction, or do we just
My sense is if we kind of, really kind of limit this to the scope of what we actually decide tonight, the only choice we really have here is whether or not staff are saying that as it's being used right now, is it legal? And well, I do think there's value to their, suits to make this work. Of course, providing, affordable, safe housing for Utah residents, to PROVO residents is, really, important right now. I just don't know that in our purview, the ability.
Right. Thinking from my other experience.
I've got one more question. Besides the current tenant situation, would there be a different combination of tenants? Like if the property owner lived there and the other people in the property were family members only, would that be allowed under the current zoning?
So the current legal use is 2 units, which would be a family or 3 singles. So the applicant's family could live in 1 unit and he could rent the other unit to a family or 3 singles.
Is it
the legal use?
Is it a unit with an accessory apartment?
No, it's just a single family or 3 singles. If it were a single family home, the zone would allow for owner occupancy to have an accessory apartment, but this isn't a single family, it's a 2-family home, which is essentially that, but you don't have to have the owner occupancy requirement. He could rent out both units to 2 families and he could go live on a different property somewhere.
Okay.
That would be the distinction between those.
Other comments? Otherwise, I think we're broadly in agreement.
Right. I don't think we've had full public comment
Oh,
yet.
right.
I don't know
Of
if
course,
somebody
getting ahead of
wants to-
myself. I kind of looked at the room and hey, do we have any other members of the public that would like to speak?
Hi, I'm Deshawn Hibbard, and I'm currently living in the basement with my husband. And we wrote the letter. I don't know if you guys were able to read it. But it is a great place to live, and moving would be really hard for us, especially in the middle of a semester. I'm a full-time student. My husband works full-time. I also work. So it would be very difficult for us to just up and move, especially when there's not a lot of good options available in Provo. Right now, since everybody's still here, that would be different when people are moving out for the summer. But financially, it is a lot cheaper option and a bigger space than a lot of other places provide, since there's 2 bedrooms, which is very accommodating. I don't know if this is important or not, but there are also other houses right next to us, not just apartment complexes, but other houses that have 4 units in them. It'd be 142 East, 300 North, has 4 units, and so does 107 East and 300 North. I don't know if that makes a difference, but they are also just houses, and they have 4 units in them, where the house that we're living in right now has 3. I would just like to invite you guys to look at it from our perspective as living in Provo as students, as a married couple. It is very difficult to find housing. I don't know if you guys have ever done that process, but it's just very competitive. If you post that you're selling a places open up, you get 150 responses from so many different people who are looking for places to live. And so if we would have to compete with all of these different people to just find a different place to live would be very difficult. But thank you. I don't know if you have any questions for me, but.
Thank you very much. I think everyone else is on payroll here.
The unfortunate thing about these situations is, as the young lady has said, the people who get the short end of the stick are the renters. And it puts us, as the zoning enforcement department, into a very awkward position because we're constantly being criticized for not doing enough over occupancy issues. I mean, constantly. With reasonable accommodations, we try to make it as clear as possible and as documented as possible that that is a temporary dwelling unit. And when the person who was given that reasonable accommodation is no longer there, the extra unit is no longer there. I would be happy to work with the property owner and with this tenant and not forcing some type of immediate vacation of the dwelling in order to help work with the time frame that she's under right now. Yes, moving in the middle of a semester is not easy. Moving to between semesters is only slightly easier. There are open apartments around. There's a whole lot by the stadium, but they're very expensive. They're quite a bit more expensive than I'm sure these basement apartments rent for. So I appreciate the position she's in, and we'd be happy to try to work out something that's not so draconian if we can.
Question for you. If the property owner were to apply for a zoning change, does this action get stayed while that goes through the process?
That is so independent of this. I think it would probably not be a good idea to stay this. Although I don't have the
I'm not
Joaquin
saying
neighbor.
this particular thing, but if we decide that the city did not make a mistake and the property owner decides to follow up with an application for a zoning change or a variance or something along those lines, does the enforcement action get stayed?
We could do that. One thing I would have to look at is the neighborhood plan. If the neighborhood plan anticipates, this would be an MDR zone. The neighborhood plan anticipates an MDR zone down this far south in Joaquin, I'd be willing to stay it. My recollection of that land use map is that it does not call for that. That by the time you get this far south in Joaquin, it does not call for that type of rezoning. So if we're following the neighborhood plan, I'd be willing to stay enforcement until the rezoning process goes through. If the neighborhood plan doesn't call for that, I probably wouldn't.
Okay.
More deliberation? Are we ready for Vote. We have one person have a different opinion this time.
Yeah, I'm thinking about, if in the last issue we had where there was a whole bunch of neighborhood people come and talk about how they were negatively impacted by a decision, and we were talking about someone's view being obstructed. Like, kicking people out of their house is, for me, a million times more impactful to residents of a neighborhood than that. The other concern I have is, I know when the RC zone was originally put, when it was implemented, it was put on places I don't think it was ever appropriate to put. There are commercial buildings in my neighborhood that are zoned RC now, and I feel like it was kind of put in a broad strokes over places it shouldn't have been. And that if this property already had 3 units on it before the RC zone was placed, which I think it did, I don't think it's fair to have them lose a unit even 20 years later because of that.
So are you kind of invoking some kind of grandfathered right? Because I mean, it seems like the conversation today has been more of, this was kind of this is just the kind of hinges on that temporary accommodation. I mean, if you can show me a mechanism where we can just allow them to stay, I mean, that's probably preferable.
I do think that the issue of when that 3rd unit was built and when the current zone was applied is part of what staff should have determined. And so given the current zone, it doesn't sound to me like this fits, but if that particular configuration existed before the zone, then it might be a mistake on the part of staff to have,
if it existed legally
beforehand. And I think that determination is not part of our record here.
This whole termination of what was established legally and not legally has been kind of the bane of Provo's existence for many years. Yes, especially in downtown neighborhoods. And so I think I really do appreciate staff's attempt, or not attempt, but their effort to follow up on this action. There was, a reasonable zoning accommodation attached to this property that no longer applies to the property, and they're following up on it. And it's not being forgotten about. It's not being swept under the rug. I really appreciate that. And so I don't think it's a mistake on Provo City's part to enforce that, regardless of who the property owner is. So nothing against you, sir. So I think that this item needs to be upheld, but I would encourage, if staff feels, following that, if there were enough votes to approve this item, I would encourage the property owner to work with staff to see if that property or if the use is appropriate for more than 2 units. And anybody who knows me knows that this is very hard for me to say because I am not hugely in favor of increasing units, but I know where this is at, and I know what's around it. And so, you know, if there's enough parking and all of that, if it meets all the other criteria, which isn't up to me to decide, but, you know, I trust staff. And so, you know, my opinion is let's uphold this. I appreciate the staff's diligence. But I think that the property owner and staff could come together and work out something that would potentially maintain all 3 units. I don't know, but I think there's room there.
Kind of feel the same way. I think that there is, my recollection of some of the discussions from Planning Commission and from our work meetings was that the city was looking to increase accessory apartments and increase like infill density. And this isn't quite that, but it seems to me to fit the spirit of that policy, maybe not the letter. And so I agree that specifically in terms of the reasonable accommodation that has expired, I don't think the city has made a wrong determination, but I think that there may be a deeper issue that the city has not considered, and that they should allow the property owner to pursue that. I'm prepared to make a motion if they're. Okay, I move that we deny the appeal of the staff determination of illegal use of a 2-family dwelling for the property at 129, 131 East, 300 residential conservation zone, with a recommendation that the city allow the property owner to seek remediation options separate from this, if they're appropriate. I can find that the decision of the city, specifically with respect to the reasonable expiration of the reasonable accommodation, was not incorrect.
I'll second.
You. Discussion we did last time, and
I'm going to vote nay because I do not think it should be classified as a 2-family dwelling. Because I don't think a 2-family dwelling is the right classification for this property.
This is hard. I will vote aye.
will vote
Aye.
one vote. The appeal is aye, and the staff recommendation is upheld, again with the recommendation that I think we turn our meeting. All for your participation.
Thank you.
Sure.